And thank you very much for being here on a Saturday morning at 9 a.m. after three long and stimulating day. Thank you so much. I'm very pleased and honored to be moderating this panel on a very interesting topic that highlights the very critical situation of human rights protection system at the regional level. In yesterday's very moving panel on asylum members' visit in Lviv, Fianula talks about the importance of places in the imagination of international lawyers. And I could not agree more. For international human rights lawyers interested in the functioning of regional human rights system, these places are Arusha in Tanzania, San Jose in Costa Rica, Strasbourg in France, where the three regional human rights courts operate. And today, together with the Commission, the Inter-American in DC, the African Commission in Banjul in Gambia, they are without any doubt under pressure. When European states regularly threaten to denounce the European Convention on Human Rights, or when national judges are increasingly reluctant to implement the rulings of the European Court of Human Rights, it is a problem. When Venezuela denounced the jurisdiction of the Inter-American Court and its membership of the Organization of American States, as well as Nicaragua, it is also a problem. And when Benin, Côte d'Ivoire, Tanzania, and Rwanda denounce the jurisdiction of the African Court on Human and People's Rights, when the ruling of the African Court are not at all implemented, it is also a critical problem. And it is important so today to reflect on the pressure these courts face. So in this context, we need to understand how the courts deal with its adverse political context. With this in mind, I'm very delighted to introduce you to three eminent scholars, one of whom is a specialist of each system. In alphabetic order, they are with us today. Álvaro Pol is associate professor at the Pontificia Universidad Católica de Chile. He has written extensively in the Inter-American human rights system, since this is doctoral PhD concerning the evidence before the Inter-American Court. Álvaro has also intervened before the Inter-American human rights system in various capacities as lawyer, expert, amicus curiae. Sungurua Undumbana, who is in Nigeria today, but thanks to the modern technology we have all come to know since the pandemic, he will be able to share his thought with us. Zungurua, as a professor of international law at the Human Rights Institute of Nigeria, is a well-known figure on the African continent for his impressive work, including the African human rights system, economic, social, and cultural rights, and more broadly, the interpretation of rights. Last but not least, Ghana Yudiska is currently vice chair of the UN Working Group on Arbitrary Detention and a partner at the law firm Equity Law. She was a judge and president of the section of the European Court between 2010 and 2022. So, as a former insider, if I may so, Ghana is an important European voice. So, our panel methodology is as follows today. I will pose four main questions to our panelists, and each of them will have about 5 minutes. I know it's crazy. 5 minutes to present the main points I consider important. It will be interesting because the same question will give a specific answer, maybe equivalent or not, considering each human rights system, which will allow for interesting cross-references. So I hope we will have maybe 5 minutes at the end of our panel for very, very quick questions and quick answers. So let's begin with the first question, and I will ask to Alvaro and after Nsungurua and Ghana. First question: what is the basic landscape of compliance and enforcement in this regional system, in your regional system, Alvaro? How has it performed in the past 10 years compared to the previous 10? Alvaro, you have the floor.
Thank you very much, Laurence. And I thank very much the ASIL committee for inviting me. It's an honor to be here. Well, in order to determine the basic landscape of compliance of the reparations of the inter-American system, I think it is important to remind the audience of the complexity of the reparation system of the Inter-American Court. As you may know, as opposed to the European system of human rights, which mostly or historically would grant only compensation, although nowadays it is broadening its scope of reparations, the Inter-American system, since its very beginning, orders very complex reparations that include compensation, measures of satisfaction, measures of rehabilitation, and guarantees of non-repetition, which end up requiring from states very demanding measures, which includes, well, paying compensation, asking for public apologies, modifying statutes, annulling judgments that may condemn some people, even amending the constitution or educating public officials in the area of human rights. So when it comes to the reparations of the inter-American system, the sky is the limit, or the imagination is the only limit that the court has. So as you can see, compliance with these different kinds of reparations is going to vary pretty much, or very much, sorry, depending on the kind of reparation that is required. Of course, that asking for public apologies or apologizing publicly and paying compensation are easy reparations to fulfill. And because of that, the level of compliance is, you could say, comparable to the level of compliance of the European system of human rights, which is a pretty good compliance level. Whereas when it comes to other more difficult reparations, such as amending statutes or annulling judgments, the level of compliance is much lower. Of course, it would be impossible to actually fulfill some of those requirements very easily, because they require the agreement of the legislature and many other difficult situations within a country, making the public opinion agree with what is being requested by the court. So it is very difficult, and of course you can't expect it to have the same level of compliance as what is the level of compliance of other measures. So how is this level of compliance achieved? Because I would say that because of the nature of the reparations, the level of compliance in the inter-American system is rather satisfactory. How is this satisfactory in a good sense? Okay, and how is this level of compliance met? It's certainly not because of the pressure of the OAS political system or the pressure of states, because they are not very much into naming and shaming other states in matters of human rights. So I think that compliance, or this good level of compliance, exists only because the Inter-American Court of Human Rights devised a system for monitoring compliance that is very robust, very ingenious, actually, because it's not established explicitly in the American Convention on Human Rights. It is a system that was created, let's say, 8 years after the first decision of the court. It gained momentum in 2002, and then in the 10 years after that, it became more settled. It gained its current form in the sense that it includes hearings where the commission, the representatives of the parties, and the states get together and expose what is happening. So it is now a system that is much more sophisticated than what it was originally. The problem of this is that it requires the investment of many resources of the Inter-American Court, because the number of cases that are under the system for monitoring compliance increases each year in, let's say, 10 cases or more. So this requires a significant investment of time and resources of the Inter-American Court. I would have wanted to say a few more things, but I'm over time, sorry.
Thank you for respecting the time. Thank you so much. Now, Zungurua, it will be fantastic to hear you on the same question.
Thank you very much, Lawrence. I hope the audience is hearing me.
Yes, we hear you correctly.
Is the audience? Okay, thank you very much. The African human rights system, it's a bit complex, unlike the other regional systems. There are basically three regional human rights mechanisms. We have the African Commission on Human and People's Rights, and then there is the African Court on Human and People's Rights, and then we have the African Committee of Experts on the Rights and Welfare of the Child. And each of these mechanisms were set up by different treaties, and the ratification status of each of those treaties are different, even though they are all meant for African states. So all African states have ratified the African Charter on Human and People's Rights, which creates the African Commission on Human and People's Rights. Only 34 African states have ratified the protocol that establishes the African Court on Human and People's Rights, out of which only 12 have met the Article 34.6 declaration, which allows for individuals and NGOs to approach the court. And out of those 12, 4 have withdrawn, as the moderators indicated earlier on. And then you have the African Committee on the Rights and of Experts on the Rights and Welfare of the Child. The charter was adopted in 1991, and only 50 African states have ratified. So you have different state parties across different treaties, and there are 3 different treaties establishing 3 different mechanisms. And then you also have some regional mechanisms like the ECOWAS Community Court of Justice, which also interprets some provisions of the African Charter on Human and People's Rights. So this complicates implementation. For example, the African Commission on Human and People's Rights has lots of channels of communication with states, of engagement with states towards implementation of the African Charter. And those include periodic reports, those include on-site visitation to state parties wherever there are gross violations of human rights that comes to their attention under Article 58 of the African Charter. So there are implementation that occurs between the African Commission and state parties that do not arise from communication. So to that extent, we can conclude that there's some semblance of implementation. There's a reasonable level of engagement between the African Commission on Human and People's Rights and states using the periodic report mechanism and other mechanisms available. But when it comes to complaints, petitions lodged before the Commission, the compliance level has been quite low. Over the last 10 years and the previous 10 years, there has not been much positive growth in terms of compliance. A study that was conducted in 2004 indicated that only 14% of African Commission decisions were complied with by state parties. And the current statistics is not more than that. And the situation is even more complex with the African Court on Human and People's Rights. Again, because of the challenges, some peculiar challenges with the court has. A report by the court, the annual activity report to the African Union, which was submitted in 2022, indicated that only Burkina Faso, of the cases that have been brought before the court, only Burkina Faso have fully complied with the decision of the court, with the orders of the court. As of July 2021, only 7% of judgment of the court have been fully complied with, 18% have been partially complied with, and there are 75% non-compliance with regard to the decisions of the African Court on Human and People's Rights.
Thank you.
So have stated clearly before the Executive Council that of the African Union that they are not willing to comply.
Yes.
Zungurua,
I need
with the African Committee of Experts on the Rights and Welfare of the Child. So in conclusion,
yes,
the compliance level has been quite low.
Thank you so much, and so sorry to pressure you. It was very clear, very clear. Now I give the floor to Ghana for the same question in 5 minutes. I'm sorry for this constraint.
Yeah, well, thank you very much for this opportunity to address interesting and painful topic. And in order to understand why it's painful, it's crucial to look back further than 10 years proposed by Laurent, still within 5 minutes. The most appropriate analysis would be would segment this timeline into 3 distinct periods. Before the fall of the Berlin Wall, a subsequent period of euphoria that lasted more or less 10 years, and then a phase marked by a gradual decline that continues today. So during the Iron Curtain era, the European system played a reduced role in the protection of human rights. Not many serious cases would come to Strasbourg at that time, and consequently, it was not at all hard or costly for states to enforce them. So compliance was easy. Then the post-Berlin Wall era demonstrated a wave of optimism as Eastern nations embark on a path towards integrating into the Western democratic framework. It was a time of somehow naive hopes for us, I'm speaking as an Eastern European, that joining the European family will become a short way to happy democratic future. And we were seeking assistance from the court. So that time the European court had to deal not with minor human rights adjustment, but it had to assist in building a new political system. So the convention system departed significantly from very modest goals established by its founding fathers. And what happened in terms of compliance and enforcement, post-communist states mechanically adjust their legal and constitutional systems without a real understanding by key actors of what real democracy is, what rule of law is, what separation of power means. It was imitated compliance. State have built facade institutions, or sometimes non-compliance where it was not objectively possible to comply for different reasons. And the Council of Europe bodies tolerated in a hope that the fake institutions would gradually turn into real ones. So fake it until you make it. And the court had reacted, yes, by increasing its demands, and it increased its demands equally. So the old democracies were also affected, and you can easily imagine they were not particularly happy with this. And it became especially evident when Europe faced multiple crises in 2010s, yeah, primarily terrorism, but also economic crisis, migration crisis, and so on. So that's how the backlash started in the West, materializing in a less compliance. And in the East, disillusionment with liberal democracy grew. fueled with economic challenges, corruption, perceived ineffectiveness of newly established democratic institution, and it also led to a less desire to comply with Strasbourg judgments. And the instrumentalization of those disillusions allowed authoritarian leaders to come to power, and the issue of compliance became less evident. And here, at this point, it's crucial to highlight numerous studies, well, the most famous by Harvard professor Beth Simpson, Mobilizing for Human Rights, there are many others. So it is suggested that governments are more inclined to ratify human rights treaties and to comply with them when they can comply at a reasonable cost and when political benefits of compliance are more significant than cost. And this was the case for the Western Europe after the World War II, so they demonstrated their commitments to human rights. It was the case for Eastern countries after the fall of the Berlin Wall, when people in East desperately wanted to join the European family, but this is unfortunately no longer the straightforward case. The centrifugal forces inside the European continent make the political benefits of compliance no longer attractive. And especially it became after it became clear that being a part of the regional human rights mechanism does not protect you from aggression and military conflicts.
Thank you so much, Ghana. It's very, very interesting, these cross references, because we know that, and we have seen with your three interventions that complexity was the common word. Listening to Alvaro and Sungurua, complexity of the overall African human rights system, complexity of the measure of reparation have huge consequences on the implementation level. As for you, Ghana, you have tackled the subject with a temporal approach, very interesting, showing also the new challenges, impressive new challenges in Europe. So let's turn to the second question. What is the role of judicial dialogue and other forms of cooperation across regional systems for the visibility, entrenchment, compliance with judgment and views within the system? Alvaro, one more time, you have the floor.
Thank you very much. Well, first, we must say that there is actually a dialogue between the three systems. This is not something that is necessarily going to be the case, because the systems are very different. In this dialogue, there are some systems that are more receptive than others, which may be considered a little bit more self-sufficient. You may ask whether that self-sufficiency is adequate or not. I think that it's not necessarily something inadequate, because the funding documents of the three systems and the cultural milieus in which they apply are very different. Just to give one example, Article 3 of the protocol that created the African Court of Human Rights provides that the African Court may apply not only the African Charter of Human Rights, but any other human rights treaty that may be relevant. And of course, that gives some kind of the widest jurisdiction possible of the three systems. And of course, that cannot be compared with the European system of human rights, where the court is very much into restraining itself to apply only the European Convention on Human Rights. So sometimes the lack of dialogue isn't necessarily something bad. Nevertheless, the dialogue exists, and actually, dialogue has helped overcoming some challenges of the system. Even the European system of human rights, which could be called perhaps the least receptive system, benefited from judicial dialogue. When the Berlin Wall fell, and perhaps even a little bit before that, the European system of human rights started facing very gross human rights violations, like enforced disappearances or extrajudicial executions, and that was very different to what was the case beforehand. And when the when the European system of human rights was faced with evidentiary issues regarding enforced disappearances, it took into account what the Inter-American system had done on the matter. And well, the Inter-American system was very creative when finding ways of proving enforced disappearances, which is something very difficult to prove, of course. But the Inter-American system was very creative, and the European system of human rights, which at some point started facing similar challenges to those of the Inter-American system, adopted those approaches. So judicial dialogue is very important, and it helps facing different challenges. As I said, the Inter-American system of human rights is receptive also of the European system of human rights, not that much of what happens in the African system. However, it is starting to adopt or take more into account what's happening in the African system, perhaps because nowadays there are more explicit ways of cooperation, and there are gatherings of representatives of the three systems that may produce or enrich the dialogue between the three courts. Thank you very much.
Thank you, Alvaro. Now I give the floor to Tsungurua for the same question about...
Thank you very much. Dialogue is at the heart of the African human rights system. And we could look at judicial dialogue in different levels between the African system and the other continental systems, and then dialogue within the African continent itself. The African Human Rights Courts and the African Commission have been in regular consultation and dialogue with other the Inter-American system and the European system. As a matter of fact, those other systems have been quite critical in providing technical support to the African human rights system, both in terms of training for the judges and the legal officers of the commission, as well as the courts. So dialogue has been ongoing over the years, and it is still a process that is currently going. In 2023, the African and the Inter-American Commission had a dialogue in April of 2023 to look at some of the technical and critical issues that could be of assistance to the African system. And so there are regular dialogues going on between the African system and the other. But within Africa itself, the African Court and the African Commission have been engaged in regular dialogue, because the court is, by the protocol of 1998, the court complements the protective mandate of the commission. So it's been critical that both institutions should work together to complement each other. And that dialogue, for example, led to the common rules of procedure that was adopted in 2020. And then the African Court on Human and African Court has also been engaged in judicial dialogue with even national institutions. They have heard about 5 different judicial dialogue with national judicial institutions. The last one was sometime last year, I think in December, in Nigeria, to try and enlighten the national judicial institutions on the jurisprudence of the African Court and how those jurisprudence could be infused into national courts for better understanding of the regional human rights context. And there are also dialogues that are going on between the Commission and the committee. So judicial dialogue is very critical. And also at the African Union level, there are interministerial collaboration between the human rights mechanisms and the African Union organs. For example, the Executive Council, the Pan-African Parliament, which is located in South Africa, has been engaged in aspects of the work of the mechanism for the purpose of advocacy and helping the various national institutions to understand the work of the regional mechanisms. So there are ongoing dialogues that are going on, and they are critical to the effective implementation of regional human rights systems.
Thank you so much to have highlighted the institutional dialogue between the different bodies within the Inter-American, within the African human rights system. Now, Ghana, please.
Yes, as Alvaro just rightly suggested, here again I would divide between two periods. So pre-Berlin Wall period demonstrated a respectful dialogue between equal partners. The dialogue of the European Court with the Eastern counterparts more reminded, and rightly so, a relationship between a professor and student, where the court has played a crucial role in clarifying relevant principles, the application, in raising standards of national protection of human rights and making national law compatible with the convention. And the court's role as a tutor was inevitable in Central and Eastern Europe because at that time we didn't have domestic interlocutors with established democratic traditions. However, the more the court became activist, the more criticism it faced, including from the national judicial authorities. And speaking about the role of judicial dialogue, I will mention briefly two examples, the United Kingdom and Russia. So the United Kingdom engaged into an intense public criticism and backlash against the convention system following the famous Hearst case on prisoners voting, where the court said basically that complete inability for prisoners to vote in elections violates the convention. Despite this ruling, the United Kingdom refused to amend its legislation. And then the Strasbourg court provided a bit more nuanced explanation in Scopola case, and the court clarified that the contracting states may decide either to leave this choice to the court to determine the proportionality of this measure restricting prisoners' rights, or to incorporate it into legislation. And it was only following this clarification the UK Supreme Court in a further case, unanimously dismissed the Attorney General's argument that the Strasbourg Court's decision should be omitted. And another example, the very famous Winter case, Right to Hope case, where the court concludes that irreducible life sentence is incompatible with the convention. And following this judgment, the UK Court of Appeal in the next case clarified the provisions of their legislation, which apparently were not so clear for the court examining Winter. And when the next case came to the court referred, the Strasbourg court referred to the Court of Appeal of the United Kingdom, saying, well, finally now we have clarification, and yes, the system is compatible with the convention. So the parties were satisfied with each other, and the United Kingdom remained in the convention system despite all the tensions you might observe. Now, Russia is the opposite example because following some sensitive judgments, a bill was adopted in the Russian parliament granting the Constitutional Court a power to declare the European Court's judgment non-enforceable if it allegedly violates Russian public order. So no dialogue, and the result you see. So the judicial dialogue is a crucial mechanism for navigating challenges. If there is a desire to hear each other, so such a dialogue not only enhances compliance, but it also contributes to a broader penetration of human rights principles across different systems. Yeah? And like in any relationship, if dialogue fails, if it demonstrates lack of respect, a deep dissatisfaction with one another ultimately might lead to a divorce. But we, the Council of Europe, wants its marriages with all member states to be strong and happy, and it supports with different means. For example, the subsidiarity principle, which is now put in the preamble of Protocol 15 to the Convention, and a couple of years ago, Protocol 16 entered into force, a new tool to enable a higher court from a member state to ask a question in a form of advisory opinion from the Strasbourg court for an important case pending before the national court. So any advisory opinion given by a court is non-binding, but still the intention is to facilitate dialogue and enable the dialogue to take place while the issue is still pending at the national level. And this is a dialogue we all respect, which is very helpful. Thank you.
Thank you so much, Ghana. It's very interesting because we know and we discovered listening to our panelists that dialogue is a polysemic notion. We have faced the institutional dialogue between different bodies, as Zungurua has highlighted, and Alvaro and Ghana in different ways has highlighted also the judicial dialogue between the regional courts and the domestic court, which is indeed very, very critical. So now, let's turn to the third question, the L questions. I will explain. What are the general perception within academia, diplomacy, civil society of the legitimacy, the L question, legitimacy of this system? It is a big question, I consider. Legitimacy of regional court, of international court in general, is a key question. So, Alvaro.
Thank you very much. Well, we cannot speak about the perceptions of legitimacy in society as a whole, of course, and you correctly, therefore, divided this into different sections of society, but not even in those sections, you can talk about a unique perspective. Even in country, there are different perceptions within different countries depending on the legal traditions and the cultural perceptions of how the system works. I'm just going to give an example. In Colombia, for instance, society and academia is very much used to this neo-constitutional approach to the application of law that the Constitutional Court has. So they don't have many problems with the way of acting that the Inter-American Court has, which is also, you could say, somewhat neo-constitutional somehow. Whereas in another country like Chile, which has a very legalistic tradition, it is easier to find in academia some criticisms to the way the Inter-American Court operates. Now, let's go to the different areas that you mentioned. Academia. Well, in academia, you could say that there is a general, more or less general perception of the legitimacy of the system. I see that a problem of this is that this perception is probably tied to the substantive decisions of the court and not that much to the decision-making process of the court. So if the judges or the commissioners change, probably the legitimacy will change in the sense that you get judges or commissioners with different perspective on substantive issues. The sense of legitimacy may change. So that's a problem that may occur. However, there are also some emerging voices that are criticizing a little bit the decision-making process of the court, especially a doctrine called the conventionality control doctrine, which is a very interesting legal concept, and that would be actually could be the object of a full Congress. So I won't go deep into that. Among diplomacy and states, you could say that there aren't many overt challenges to the court when we talk about the collectivity of states. There was in early 2019 some kind of challenge to the court made by 5 states of, you could say, a conservative leaning. They demanded the court to actually engage, you could say, in a more of a dialogue with the European system because they claimed for the application of the principle of subsidiarity, a little bit more margin of appreciation to states. They asked the court to take into consideration the capacities of states when ordering reparations and so on. But that criticism didn't have many effects on the system. Prior to that, there was in early 2011 a criticism called, ironically, the strengthening of the Inter-American system of human rights, which was considered by most part of academia not actually a strengthening criticism, but a criticism that wanted the Commission to have less power. This criticism was made by states of the opposite political leaning, you could say, of those that made criticism in 2019, because it was made by Nicaragua, Venezuela, Ecuador, and Brazil. This kind of challenge to the court did have some effects in procedural modifications of the way the Inter-American Commission performs. Then There are some challenges to the system, but not in a collective way, but on an individual way by some states or government officials. For instance, recently, last year actually, or at the beginning of this year, the president of Costa Rica said that he would be in favor of denouncing the American Convention on Human Rights if the Inter-American Court were to oblige states to legalize abortion. Last year, and in an ongoing process, in Peru, there is a commission within Parliament studying the possibility of denouncing the convention. However, we don't know what's going to be the result of these challenges. There are also some slight challenges in civil society, but there's no more time for talking about that.
Thank you, Alvaro. Now I give the floor to Gurua about this L question, legitimacy questions.
I think within the academia, the question of legitimacy is strong between the academia and the regional mechanisms. And that goes back to the issue of dialogue. The regional mechanisms have been engaging the academia in conferences, in workshops. The working group of the African Commission has engaged the academia in a number of its activities. And then the academia has also infused quite lots of the jurisprudence of the African human rights system. The Ogoni case decided by the African Commission, for example, the Nubia community case decided by the African Court on Human and People's Rights. A lot have been written on these cases, and also the regional human rights system is increasingly become a course content within the academic system in many African countries. So there's a strong case to be made for legitimacy of the African human rights system from the academia. The problem is with states. And even with states, we should look at the question of legitimacy from two perspectives, legal legitimacy and factual legitimacy. The African human rights system has some legal legitimacy to the extent that majority of African states have ratified the relevant instruments, except for the protocol to the African Court. All African states are parties to the African Charter on Human and People's Rights. 50 African states have ratified the African Charter on the Rights and Welfare of the Child. So there is some legitimacy to that extent. The African Union is, consisting of member states, is the one funding these regional institutions, and they receive annual reports of the activities and approve them for publication. But when it comes to compliance with decisions, as we said earlier on, that raises legitimacy question, because the compliance level is quite low, and if low compliance raises legitimacy questions, it contradicts the members' commitment to ensure an effective judicial human rights protection system for their people's benefit. It also undermines the credibility in the effectiveness and added value of the regional mechanisms. Now, from the point of view of complaints, states hardly access these mechanisms, so that also raises legitimacy questions. There's the provision for state complaint before the African Commission as well as the African Court. But states hardly lodge complaints before these institutions. Much of the complaints mechanisms have been driven by civil society organizations, that is, the non-governmental organizations and individuals. So to the extent that state hardly engages the mechanisms, to that extent the legitimacy question is a bit low. But when it comes to civil society, the legitimacy question is high, because really it's the civil society that drives the regional systems. Whether there are several observer status with the African Commission on Human and People's Rights, and they are mostly those NGOs with observer status that engages the Commission. The same goes with the African Court on Human and People's Rights. Majority of the cases that have been lodged before the court have been lodged by the non-governmental organizations. So civil society have been robustly engage with the regional mechanisms, at least to keep them afloat. But compliance low compliance by state actors actually raises legitimacy questions.
Thank you so much, Jugurua. And now the same L questions to Ghana, legitimacy question.
Well, what is the perception of legitimacy of the rule of law and human rights regional system that was unable to prevent and to stop the aggression? I'm afraid it's a bit rhetorical issue. So, of course, it's not for diplomacy. They look into the point with different lens, but speaking about civil society and academia. You know, I was speaking here at the ASIL annual meeting 2 years ago, just after the full-scale invasion. And that time I quoted Eric Posner, who quite sarcastically written that the European Court of Human Rights has presided over return of authoritarianism to Russia. And this is unfortunately very much true. For a very long period of time, the Council of Europe allowed this monster to grow, undermining legitimacy of the system in the eyes of civil society and academia, allowed for a good reason, you know, in a hope that changes might take place. But just to give you one, the most obvious maybe example, Chechnya, in 1996, when the Council of Europe was considering Russia's request for membership, the Parliamentary Assembly expressed its view on that time ongoing First Chechen War. They said that, well, we know Chechen conflict cannot be resolved by use of force, but we expect that Russia now joining the democratic family will proceed with the peace in the region with political solution based on the European democratic values. Yeah? So the Parliamentary Assembly was profoundly wrong. No political solution, especially based on European democratic values, took place. The rebels in Chechnya at that time were either co-opted or killed. The first complaints reached Strasbourg in 1999, and by the time the court delivered its first judgment in 2006, Chechnya was already run by a maniac Ramzan Kadyrov, who has been given a free hand by Moscow to run Chechnya more or less as his personal kingdom, as long as he kept so-called order, which is very different to what we believe to be a rule of law. And the Council of Europe not just was completely ineffective in stopping the violence, but it allowed institutionalization of this violence, and for decades observed that a part of its member state lived in a complete lawlessness, jungle law. And it was the first but very significant disappointment for the civil society and for academia. And then the major stakeholders ignored non-enforcement of the crucial for democracy and rule of law judgments by the European Court by some member states. Yeah? And the populistic rhetoric that, you know, European word is not the law in our country, be it Russia or Turkey or some other states, was easily swallowed for decades. So can such a system be considered and viewed as legitimate? And there is a concern that turned today into a strong perception that powerful states may increasingly ignore international law, while less powerful ones remain constrained by it, especially if they depend on support from stronger states. And that's how the legitimacy of the system is challenged, and that's where we find ourselves today.
Thank you so much, Ghana. It is in a nutshell, after these three interventions, and it is not a novelty for international lawyer, we discover that, and I quote Dzungurua, the problem with legitimacy are the states, and the last intervention shows it very well. So I have an important decision to make. We have only right now 10 minutes. I think it will be very much interesting for all of us and for the audience to take some questions and to have a Q&A session. And maybe in this question and answer, we will face maybe the question of challenges. So please introduce yourself. Thank you so much, and don't hesitate.
Thank you for Christina Cerna. I spent 3 decades with the Inter-American Commission on Human Rights. And I find the most disturbing event or a disturbing development has been the departure of states from these systems. Is there anything you think could have or should have been done differently? And what is it? To have kept these states within the system on the premise that, of course, universality is the goal. We want all of the states to be in the system, et cetera. Thank you.
Thank you so much, Christina. It's very nice to hear you.
Hi, I'm Kenny Yoshida from Hokkaido University, Japan. I've just moved to China this month, and thank you very much for this very important panel. I've been working, I'm in civil law, but I'm working on the indigenous people's law as one of my research projects. And I've been working on regional implementation across the globe compared to the situation in Japan. And I think the Alvaro mentions creativity, but I also think that there's progressiveness in the inter-American court compared to domestic court. And the same thing can be said about African system. And because I'm saying this, because the regional implementation system in East Asia or Southeast Asia is missing, as Jim Anaya mentioned in his casebook. And so there's a disparity between the Japanese domestic court or Japanese governmental position and the world standard. Japan has taken the kind of disingenuous position with regard to UNDRIP, even though it signed UNDRIP, but on the other hand, it turned their back on the very important principles such as reparations. Japanese government reject reparations and reject the right of self-determination or reject the collective idea of property notion. So, to say this, in the case of Southeastern cases, for example, in the Philippines, the indigenous peoples face very serious problems adjacent to mining problem, and there's eviction, displacement all over regarding this. So I think there's a legitimacy with regard to indigenous people. And until 21st centuries, the domestic court has been overwhelmed by the Westphalian nation state-based notion. So in that sense, the indigenous peoples, generally speaking, across the globe, are oppressed, neglected by the domestic court. And so there should be the need for the regional implementation system. And I just started to talk to the leader of the, okay, I'm going to end. Leader of the National Human Rights Commission in Korea to establish the regional implementation system in East Asia as well. So I'd like to listen to some of your comments, advice, and or responses to my question. Thank you.
Okay, thank you, dear colleague.
Good morning. My name is Maria Alba. I'm an LLM student at George Washington University. My question is principle for Alvaro and Ghana. One of the main challenges the Inter-American Commission and the American system is the procedural delay. Do you consider that at any point eliminating the Inter-American Commission of Human Rights as the European system did will help to improve this issue? That is my question for you.
Thank you. Thank you so much. So maybe we will have a kind of a tour, and you can answer the question you want to answer. Okay, Alvaro?
Well, thank you very much for the questions. I see that we have only 4 minutes and a half, so I don't know if we would be able to answer all the questions. But well, to the questions of Cristina Sedna, I think that there are two kinds of states. The states that simply don't have a good attitude towards human rights, as, I don't know, Venezuela. And it is, which was one of the countries that denounced the convention. And in those sort of cases, there's no real way of keeping them inside the system, and unless the system is somehow lenient towards human rights violations, which is a big problem. There are other countries, on the other hand, that do have a true concern for human rights. However, they have a different conception of human rights to those of the court. What do I mean by this? Human rights are supposed to be a universal reality in which we should all agree. So the Universal Declaration of Human Rights and the American Convention on Human Rights tried to establish some minimum standards. And that's why all states agreed to those minimum standards. But there are some rights that may have actually opposite interpretations. And a way of retaining states of goodwill, but which have a different interpretation of human rights, would be to grant them somehow a margin of appreciation, so that they can live human rights according to their reality. I mean, giving a well-known example of Europe, the principle of laïcité in France is absolutely different to the principle of an established religion of the UK and Denmark. But nevertheless, those two absolute different realities fulfill with the right to freedom of religion. In the Inter-American system, the Inter-American Court seems to try to establish only one way of fulfilling some rights. And that is something that could be deterring some states that have a goodwill towards human rights, but which have a different understanding of the concept or the way in which human rights could be implemented. I would love to say something else, something about the question of the delay of the Inter-American system. But I don't think I have the time, unfortunately. Yeah. But if you wish, we can talk about that after the presentation.
Thank you so much. Yes, during the coffee break, we will have plenty of time. It will be nice. Zungurua, maybe you can present what our Japanese colleague have highlighted about indigenous people, and the Ojek case in the African court is very well known. But let's you can choose every angle you want in order to tackle one of the questions.
Yeah, the Ojek case is an important issue, but implementation is also a problem because of historical. Implementing some of these decisions must fit into historical challenges in different sociological challenges in different countries.
Yes.
But it's not an issue that we would go into at the moment because of time.
Yes.
I merely wanted to highlight on the procedural problems in the Inter-American system, which is similar to the African system.
True.
And part of that problem is because of the treaties. The African system, for example, contains elements that causes delay, like the admissibility procedure, which sometimes question of admissibility takes 2-3 years to resolve. And I think it might be better to adopt the example of the ECOWAS Community Court of Justice, which does not make provision for admissibility, so that human rights questions can go into merit cases straight without the delays of admissibility. But I think more crucially, it's important to address the problem of withdrawals of declaration by states in the African system as it affects the African Court on Human and People's Rights. Currently, there are only 8 states remaining that have met the Article 34.6 declaration out of over 30 states that are ratified. And that means that the African Court is grossly underutilized at the present. So something needs to be done, and I think there is need for advocacy by civil society to get states to probably adopt a supplementary protocol to remove Article 34.6 from the protocol. to allow individuals and NGO to have direct access to the court.
Yes.
That would enhance the effectiveness of the African court and also enhance the legitimacy of the court. I think I'll leave it at this point.
Thank you so much. Thank you so much, because we need to hear Ghana.
Well, thank you. Christina, thank you so much for your questions. This is the issue we discussed for years. What we are doing with the states who go clearly into an authoritarian path, do we still keep them into the system, hoping for a dialogue, and at the same time giving a possibility to people to keep this chance to complain and to get their judgment, and then maybe it will be enforced if it's not very sensitive, or we should just expel them. And yes, Alvaro, you said it's always room for margin of appreciation, but when it comes to clear values of the organization, and that I believe is exactly what Christina meant, and now with the experience we faced, I'm afraid we came to a conclusion that keeping some states with clear authoritarian regimes within the club of democracies and allowing them what we call a la carte approach to the organization values undermines, on the one hand, the authority of the organization itself, and on the other hand, does not bring anything good to the people of this country, does not bring democracy, does not protect anything in the state. So unfortunately, today, I think we a little bit changed our approach to this question. And speaking about procedural about actually long delay in examination of cases, yes, it's also a crucial problem. And unfortunately, in the court, we realize that, well, yes, we have a huge backlog and we have to deal with all cases, but cases that reflect the major issues for the state concern should be taken the first. We introduced this rule only in some 2015, 2016, a little bit too late.
Thank you so much for these last words. The time is now completely finished. I think we need to applaud very, very strongly, a round of applause, our fantastic panelists. Thank you one more time for your presence Saturday morning. It has been very important for all of us to have your support today, this morning. Thank you so much, and let's continue our discussion during the coffee break. No.
For the CLE, the code is sheep.